warm welcome to Bharata First. You're watching Big Picture. I'm Frank Razam Pereira. Since you're here, I would like to thank you for your continued support. For those of you who haven't already subscribed, please like the video, subscribe, hit the bell icon, and then all notifications. Do follow our social media handles for all the latest updates, and you can also subscribe to our newsletter to get some incisive content. The Bharata First team runs a daily Big Picture quiz. Please do participate by going through the description in Big Picture videos. Here are the UPI IDs for those of you who would like to come forward and contribute. You can also contribute by using our contribution link, which is provided in the description box in case you find it difficult to use the UPI IDs. A small contribution that you make will be a giant leap for us to keep bringing you this content. So do continue to show your love and support. I need it now more so than ever. All this information along with many more recommendations are in the description of this video. Please go through it. And now on to the discussion. The Supreme Court's E-Committee has released draft model rules for the live streaming and recording of court proceedings and invited feedback and suggestions from the public. Once live streaming starts, people would be able to watch the proceedings of any court, including the Apex Court and the High Courts, on their electronic gadgets from anywhere in the country. Certain sensitive cases like rape and matrimonial disputes will not be live streamed. However, while live streaming in certain cases may be restricted to the final arguments only. The live streaming will enable people to watch court proceedings on matters of public interest and benefit journalists, civil society, academics, and law students who are unable to physically attend court because of geographical, logistical, or infrastructural reasons. In this edition of Big Picture, we will analyze live streaming of cases and e-courts, also virtual courts. Joining me on the program today are Piyush Singh, Advocate of the Supreme Court, and Subimal Bhattacharjee, Cyber Technology Expert. Thank you to both my guests for joining me on this edition of Big Picture. Piyush, let me start the program with you first. Let's first try and understand, this whole issue of live streaming and where it stands and your thoughts on live streaming of cases.
Frank, when e-courts were introduced, before that, of course, before the pre-COVID era, we had open courts in the country. And with open court system, there used to be, I would say, a live reporting by most of the journalists who used to be part of the court proceedings. So they used to watch the court proceedings, they used to observe the court proceedings, and that used to be broadcasted. And most of the proceedings were actually at a very level, at the very, be it a district courts or the high courts or the Supreme Court. So there was a concept of the culture of open court hearings. Now with the e-courts coming in, there are links for most of the courts. Of course, those are shared with the lawyers and at times with the journalists also. At times, you may not call it an open court because it is not available to the public at large. And also at times not to journalists at large or to the people or available to the media at large, most of the times. So the live proceedings which the Supreme Court has mulled, I would say is a very important step in bringing transparency into the system. Because there is a very famous legal jurisprudence, or I would say very famous concept in legal jurisprudence, that justice should not only be done, but should be seen to be done. So what is important is that people should be aware that how court proceedings are taking place. People should be aware how justice is dispensed with, and people should be aware that how a particular decision has been taken. Now, for most of the time, for example, even when people read headlines in the newspaper that a particular high court has taken a view on a next debate or a next topic, or a particular Supreme Court judgment on maybe on an Ayodhya verdict. Now, people do not understand that what were the arguments which were produced before the court. People do not understand what were the documents which were there. At times, people do not even understand or people do not even realize that what were the kind of counter arguments were taken by both the parties. Because it may be a judgment which was by consent, or the other party actually didn't relent to a judgment or gave a consent to that judgment. So most of the time, there are a lot of things which are in the background which go in a judgment being pronounced by a court. And in case those are live proceedings, it actually will bring a lot more transparency into the system, which is required. Definitely a very welcome step, especially in the times of e-courts when ideally most of the people have links to the courts. They can actually watch the proceedings. So there is no harm in having live proceedings in such cases, where especially a matter of national importance. When we're talking about privacy law, for example. So imagine, even for the sake of academic discussion for the people of this country and otherwise, the judgment or the proceedings on the law of privacy would be very important for everyone to realize that what is privacy, what is Supreme Court trying to protect, what is Supreme Court is also aware that till what extent privacy or the law of privacy can be misused. All those arguments are very important, and I think live proceedings is a very welcome step. Supreme Court was thinking on working for it for a very long time. Of course, there are some exceptions to live proceedings, which I'll be maybe will be discussing in the show later on. But I would say it's a very welcome step.
Absolutely. Indeed, we will talk about the exceptions as far as live proceedings are concerned, but no doubt, legal matters are looked at by the common man as very complex issues. So if we can, show them and telecast them to the people, they can probably understand it a little better because they can see what's happening right in front of them. All right, Subimal Bhattacharya, I'm coming back. Let me come to you now, and let's talk about this aspect from a technology point of view and from a tech perspective. How would you look at it? What is the kind of technology that we require? Because we do not want to have some unscrupulous elements misusing any of these services, if we can call it that, being given to the masses.
Sure, Frank. Firstly, if you see way back in 2007, under the National E-Governance Program, e-courts was conceptualized as as a mission mode program. And of course, from 2005, the Chief Justice of the Supreme Court had initiated the effort to, get the courts into the E mode. Now, over these years, a phase one implementation has happened, which primarily, of course, was the technical aspect was done by the NIC, the Government of India organization primarily. And a phase two is just, being spoken about and would be implemented, where a lot of focus would, move even to cloud computing. So if you look at the whole efforts around e-courts and then even take the live proceedings and the coverage, it actually got the fillip or a lot of, I would say, even acceptability among the senior lawyers have also happened only because at the time of the pandemic, there was no other option but to, use this whole phenomena. And by and large, many of the high courts and even at the district and the taluka courts also, implementation, has happened. You have 39 high courts presence across the country, and then you have more than some 3,500, I think, the district and the taluka courts. Now, so when you are getting into the whole e-court infrastructure, you are getting into a simplest network where you would have to factor in so many of these, presence as such, which you have to enable with the e-court. So, and of course, the pendency of the cases with each of these courts. So you have to deal with it. Now, whether it brings in efficiency, yes, as Advocate Piyush had just now mentioned, that it brings a lot of transparency also today because of possibly bar and bench and live law. A lot of people understand, almost in some time about what is happening in a court, but still, you are still hearing from a third party. So the importance is felt. Now, technically, how do you dress up the whole infrastructure? So basically, apart from the judges being enabled or the registry being enabled of those courts, putting them to the server infrastructure, putting them, to the CIS infrastructure. There is a court information software that has been worked by NIC, and that, of course, also has been upgraded in phase two. It will be upgraded to even more features to factor in all of the cloud computing that is being thought about. So a seamless, a network that can deliver, a network that will ensure that, only the judges and the parties concerned only have access, when hearings are happening and all. Of course, there is a system already in place in the current methodology to have a unique identity for each of the judicial officers and people associated with it. But all of that would be further more streamlined. I would think that an Aadhaar like kind of a structure would actually evolve around the whole judicial network that is being planned. There is a wider national judicial information system network in which every court's information, the district legal service, I think bodies there, staff gets in, everything would become a kind of a repository. And of course, the websites are already of the courts available today with a lot of information, but the technical enablement with the hardware, with the software, with the linkages in a secure way, with proper cybersecurity measures, these are being very closely taken up in the phase 2 of the implementation. And since it has the attention of the government of the day in terms of keeping it as, again, one of the mission mode programs under the e-governance enablement that's happening, I think, in over a period of time, it will be something that everyone will get accustomed to. And along with the open courts, e-courts would also become very, very much in the parlance.
Absolutely. Now, Piyush, since we are here and you were making the point earlier about, certain exceptions really as far as live proceedings are concerned, there are several sensitive cases and sensitive matters that go to court as well. And this happens more often than not. So, where are some exceptions, or where can some exceptions be made as far as live proceedings are concerned, or televising live proceedings?
Right. Frank, for the benefit of all the viewers, I would like to differentiate live proceedings with e-courts and virtual courts. So live proceedings is something which has been noted very recently by the Supreme Court, that all the hearings which are happening in the virtual courts or the e-courts would be live, would be broadcasted to the public at large at an exclusive, and it may be at a live stage. What e-courts was there pre-pandemic or pre-COVID era, what e-courts were, the system was laid down by the Indian judiciary was more of having the e-software for uploading of documents and cause lists and data, and also for the filing. So the courts were having that paradigm shift, as Mr. Bhattacharjee has stated, from 2007, the first phase has begun. So that the first phase was majorly about having those cause lists and that filing stage to be done by a virtual mode. But the phase for virtual courts, I would say, really kicked in from the COVID, the first phase of the COVID. From, I would say, from April 2020, the e-courts turned into virtual courts. And these virtual courts have been so far very effective. And when I'm talking about the exceptions to the virtual courts or to the live proceedings, because the exceptions would be the same, would be for matters, especially where Witness Protection Act, which is not presently there in India, because that law is being presently being thought after, and the bill is already tabled. So witness protection is one of the most important, where the witnesses require protection. Their information should not be disclosed to public at large, number one. And also for cases which are covered under a sensitive law like POCSO, so which is against sexual crimes against children or against somebody who's not being an adult. Also rape cases and statements under a offense or a sexual offense cases. All those statements are also covered, which cannot be lively broadcasted. Even the name of those witnesses or the victim, as has been stated by a lot of Supreme Court judgments, even the name of the victim cannot be stated in a judgment. So all these cases, especially with respect to sexual offenses, or maybe a matter which is related to national integrity or security, national security, these are some of the cases which have been excluded from the database, or which are excluded from live proceedings or e-courts. So these are, I would say, a few of the exceptions which have been tabled out, or which are not there, which cannot be live broadcasted.
Right. Points taken. Okay. So, Vimal, coming back to you now, let's talk about this other aspect, because there are several members from within the advocates fraternity, the lawyers fraternity, who have come out and spoken about how the pandemic has hit them hard and they have not been able to adapt and adopt to this technology. So will this help only a certain section of lawyers?
Frank, I would think that changes the name of the game. So everyone has to adopt as well as adapt themselves. And if you see the advantages, like Mr. Piyush, he can attend a Supreme Court hearing, and then after some time attend a High Court hearing in Guwahati or Kerala or somewhere else. So the advantage of a lawyer in this ecosystem is far much higher. His you know you can say his application of mind, his ease at to argue, I would think is further enabled, because let us assume someone in Delhi who is arguing a case in the Supreme Court and then has to go to the High Court in the afternoon. Somewhere it is getting delayed here, so he seeks time. So all of these things, I think a certain efficiency definitely comes in, where you are not caught in the merely in the traffic in the road or needing to travel somewhere else, all of that. So I think this is definitely of advantage, whether it is to a young lawyer or even sorry, to the senior lawyers. Number two, I would think that another way that it improves the scenario is that the situation where a lot of adjournments are very easily sought and all. I think to an extent this also would be kind of addressed, because people would be observing once the live proceedings go, once this activity happens, and people will observe that who are the people who would actually want to seek an adjournment without moving a case ahead and all. So I think the efficiency of everyone on the legal side definitely improves. I would think that there is an ease. There isn't something that it's very difficult to get into a courtroom kind of an atmosphere. It's a question of time. Even people like us who have been doing so much of those webinars and the Zooms and these things, sometimes we don't like seeing every time so many small icons in the screen and everything, and also, but I think it still improves on the efficiency, and you over a period of time you get into it. So I would think that the future definitely, as I said earlier, also it would be a mixture of e-court and open courts, and of course live proceedings become the order of the day, as Mr. Piyush has very well said, that there are many cases, sensitive cases, that you don't bring into the picture. But by and large, everything on a live proceeding gives you an opportunity to follow a case. There are multiple sections of the society who benefit by such kind of observation, whether it's one of your civil servant aspirant on a particular issue, or even people like us, practitioners in certain areas. We have a first-hand understanding and a knowledge of what happened in the court. It always helps in improvement of the discourse at the end of the day, and by and large benefits the society.
Absolutely. All right. Time to get quick closing comments now from both my panelists with the best way forward. Starting first with you, Piyush.
The e-courts, Frank, are a very welcome step. They are accessible. That is very important. So accessible from throughout the country. The litigant, lawyers, and everyone can access the proceedings. They are affordable. Previously, for any matter, traveling to the High Court, for example, somebody traveling from Ghaziabad to a High Court in like a big last state like Uttar Pradesh to the Allahabad High Court, for every matter, for every date of hearing, was very difficult. Now, somebody sitting in his own district or even in his own house can watch the proceedings. So for the litigants, for the lawyers, and for the complete infrastructure, I would say it becomes much more affordable also. So what needs to be looked into, which will be very important, would be the technological glitches which are there. They needs to be addressed. Very recently, what we saw in the matter before the Delhi High Court, in one of the Juhi Chawla matter, in the 5G matter, where there was complete disruption of the proceedings. Definitely, I would say such issues can be addressed by small technical, or I would say the platform advancement, like for all the clients or for all the people who will not be arguing a matter, a link can be given to them where they can watch the proceedings but cannot participate. Right now, what is happening, Frank, is a common link is generated where anyone can speak, and even the video or audio can be muted by only by the court master in those cases, where anyone can participate in the proceedings. So the link is common. So just by small technological advancement, we can move far ahead, because I would recollect when we had started the virtual courts, this transition happened in April and May of 2020. As you had rightly asked Mr. Bhattacharjee, that how lawyers are faring with it. So there was a huge resistance from lawyers themselves. But now I would say most of the lawyers are accustomed to it and they welcome the step, especially after the second COVID wave, In fact, I would say most lawyers are benefiting. But the question is not about lawyers benefiting or not, because lawyers, I would say, are part of the complete system and they are one of the stakeholders. They are not the complete system in themselves. So I would say it's the more important it's for the litigants, because a faster disposal of a case also impacts a country's economy. For example, a commercial dispute getting adjudicated at a faster pace is good for any foreign investment which flows into the country. A criminal case getting adjudicated is a very huge benefit for country's law and order. And a real estate matter being adjudicated again is a huge benefit for the complete country's social security. So, in case the disposals take place through virtual hearings, and I would say, as Mr. Bhattacharya has rightly pointed out, in virtual mode, the adjournments are far less, because previously there used to be 101 reasons for either lawyers, for litigants, or even the bench. With all due respect, even the bench used to give 10 reasons for adjournments, that the file is not available, staff is not available, the steno is not available. Lawyers, they had their own 101 reasons for adjournments. The litigants had their own reasons, the witnesses had their own reasons. Now, with the virtual courts happening, most of the reasons I would say would not be relevant in these proceedings. So, definitely, it's one of the most important, or I would say it's a blessing in disguise. And in Socratic words, in Republic, as Plato has written, that our need will be the real creator. So it is a need right now for the country, considering huge pendency which is there. So it's a very welcome step. The only thing, we need to technologically advance the platforms which are there so that the data can be protected, which the files uploading system, so that can help into the advance.
Absolutely. I think this is a very, very valid point that Piyush has raised, Suvimal, and I'd like to take that forward with you with the closing comment from you on this issue of Juhi Chawla. And, it made national news, not just her talking about 5G, but what happened at the proceedings itself. And at a high court proceeding, if this can happen, isn't it isn't it a shame? I mean, how do we ensure that we safeguard against these kind of things?
Yeah, I think this is a trigger for looking at this aspect very much closely, and obviously the court has absolutely done the right thing in penalizing her, because it was she who had passed on the information for connecting. But having said so, that NIC is seized of the matter right from the beginning through the CIS and now into this phase 2 and then subsequently the phase 3. I think it is incumbent upon them to be able to devise a platform or even the whole ecosystem where the sole control, remains with the registry or whatever the Supreme Court expert committee, that E-committee that they call, to decide about how the whole courtroom proceedings happen. So I think
The question really is, I'm sorry to interrupt, Suvimal. Do we have the technology in place to ensure that we can safeguard against this from a technology point of view?
Yeah, it is possible. It has to be, tailor made in that way about who has the control. And that's what I'm saying, that the committee decides about where the control remains in a particular courtroom, and accordingly it is implemented, who has to have access, who can speak, who can interject. That can be purely, defined, technology is available. Number two, I think the demand for courtrooms, that of course is always there. A lot of judges can now even securely, uh, sit in judgments even from their own rooms, uh, because at the end of the day, you just need a secure system, and in a way, uh, with increasing number of cases coming, with more judges coming in, all the time, you are trying to look for courtrooms, and the time that gets spent in moving around and everything. I think even to an extent, there would be definitely a benefit, particularly in the lower courts and all, where there is a kind of a chaos, like a kind of a situation in many situations. I think this could bring in a certain sense of order, and the respective high courts really have to take a role in trying to put all these district and taluka courts in order. Most importantly,
Right.
Frank, what's important in this whole effort is that we have now got a trigger to do something, that transformational change. And in that, we have the capacity in terms of technology. We have the intent in terms of the, courts themselves, or their government as well as the judiciary wanting that to happen. We have the money also available to implement it. I think the harmonization, even with the legal fraternity as well as the litigants over this period of this pandemic, has happened to an extent to give the confidence. It's a question that we have to implement, because at the end of the day, justice delayed is justice denied, and this is where this can make a huge difference. The pendency list always hurts. In each and every single case has so much of trails that go on. So everyone gets justice, I think, in a far much transparent and in a far much optimized time frame, I would think, if we are into this whole system.
Absolutely. All right, gentlemen, we'll have to leave it at that. Thank you so much for joining me on the program and putting things into perspective for us. Well, what's coming out of this discussion is that live streaming of proceedings and e-courts are a step in the right direction. Making live proceedings available for all will ensure participation from the general public in important matters. Law is considered a complex subject by the common man. Live proceedings will help the public in understanding these complex issues in a better manner. E-courts and virtual courts have made things more accessible and affordable from an all-round legal perspective. However, the technical glitches need to be addressed at the earliest, because that is a major problem, and that is something that we saw in the 5G Juhi Chawla case as well, and we do not want to see a repeat of that, especially when it comes to very serious issues in court. The pendency of cases can also be addressed through this. All stakeholders need to adopt and adapt, since the advantages outnumber the disadvantages in a big way. Once again, thank you for your continued support. For those of you who haven't already subscribed, please like the video, subscribe, hit the bell icon and then all notifications, and ensure that you share this video as well. Do follow our social media handles for all the latest updates, and you can also subscribe to our newsletter to get some incisive content. The Bharata First team runs a daily Big Picture quiz. Please do participate by going through the description in Big Picture videos. Here are the UPI IDs for those of you who would like to come forward and make a contribution. If you find it difficult to use the UPI IDs, a payment link is in the description box below. You can use it to make a small contribution. A small contribution that you make will be a giant leap for us to keep bringing you this content. So do continue to show your love and support. I need it now more so than ever. All this information along with some must-see recommendations are in the description of this video. Please go through it. That's it from me. See you again next time.